Grazie Gianni, grazie Gigliola Toniolo, grazie a voi tutti. Gli spunti sono molti, quindi pregherei Gianni di farmi questo invito.
Thank you, Gianni. Thank you, Gigliola Toniolo, for this invitation. There's been significant food for thought, so let me please ask Gianni to warn me when I'm to close. I've prepared a few slides with sort of table of contents. I've slightly changed them this morning, considering the interesting speeches I've heard. I'm very glad to be able to join this conference. I'm here on behalf of the CGIL INCA European Monitoring Center on Social Policies, in charge of analyzing and comparing social policies of different countries. INCA CGIL is the institute of CGIL, whose mission is to give social and legal assistance to people who have difficulties in having access to social protection rights. INCA is based in all municipalities in Italy, and it operates in more than 30 countries in the world, so that these protection rights can also be ensured for citizens or nationals who move to other countries, whether they are Italian citizens residing abroad or nationals from other countries who would like to see their social protection rights acknowledged and enforced in Italy. I have been living in Belgium for many years now, and I work in Belgium. Therefore, my perspective is also based on the Belgian situation, where where rights in a lay perspective are more advanced than in Italy. I work for a lay secular association which supports secularization in Italy, and our mission is to organize initiatives in Belgium so that the Italian context can be better known in Belgium, and organize initiatives in Italy so that the Belgian more advanced and progressive frame can be better understood and known in Italy. So as INCA CGIL, we have been working on mobility rights and free movement rights for many years. Our perspective regards welfare and social protection rights. I would like to stress in my first slide a similarity that was also emphasized by Gianni. We have been carrying out a research study in the past few years based on a practical case and the case of rainbow families. Now, this picture you can see here is our passport of rights. It's in 3 languages, in Italian, French, and English. This passport summarizes in an accessible language the portable rights of citizens who move to a different country. I will tell you more specifically what portable rights mean. Basically, it means that when you move from one country to another one in the European Union, you are entitled not to lose your rights. And this also applies to citizens from third countries. At present, we are engaged in a more specific project whose aim is to investigate atypical jobs in the larger framework of freedom of movement of workers in the European Union. This is a comparative study on 8 EU countries, namely employees or workers who have an atypical employment contract, so no fixed job location, no fixed office, no fixed term contract. Well, these workers can easily lose their rights when they move to another country. We've written a report on this project, and it is a 30-page report written in English and Italian, and if you want to consult it, you can make an official request via mail, and we will send you a copy. Now let's move back in time. On September 25th, 1958, the European Union, called the European Economic Community, had been newly founded, and only the linguistic regime of the newly founded European Community had been established, as well as the status of European officials. The first legislative act issued was Regulation number 3 of September the 25th, 1958, concerning social security of migrant workers. Therefore, freedom of movement is a founding pillar of the European Economic Community. At that time, reference was made to the free movement of workers, both wage earners and self-employed workers. That responded to the need for flexible and mobile workers who could move from one country to another one. And, of course, the main hindrance to the free movement of workers might be, of course, the existence of different social security systems. At that time, the European Economic Community counted only 6 founding members, 6 countries. These member states were basically homogeneous in terms of the way in which their social security system worked. The free movement was a different concept as compared to the concept of free movement we have today. But what is interesting is that free movement as a principle was born in parallel with the establishment of the European Economic Community. Freedom of movement meant free movement of goods, free movement of services, free movement of capital, and free movement of people. At that time, there was awareness of 2 different options. On the one hand, you could choose to harmonize social policies. On the other hand, you could choose to coordinate social policies, considering the gap that existed between the different social policy and social security systems. Harmonization means establishing equal social rights in all countries and basic guarantee rights, for instance, establishing that an unemployment fund or benefit is established in case of dismissal or sacking, or establishing that the payment of insurance contributions would entitle contributors to receive pensions. On the other hand, coordination meant that different social security and welfare systems could speak while preserving their differences. Currently, harmonization is considered as a taboo or revolutionizing word. I think that we should somehow revise this prejudice around harmonization and reconsider the opportunity of harmonizing our social security systems. At present, trade unions are fostering the idea of harmonization. At that time, it was a very controversial choice, and at that time, those who were for harmonization rather than coordination were actually willing to support businesses. For instance, France, at the time of the economic community of carbon and steel, of coal and steel, was struggling to establish minimum social harmonization standards in order to protect French businesses that felt disadvantages compared to countries like Italy, where labor costs were lower and therefore there was unfair competition. At that time, social dumping was an issue that businesses were raising. On the one hand, you had the option of harmonization, which meant reunifying social security standards. And the second option, which was the one that was preferred, was coordinating 6 different systems. Social security systems are now more far apart than they were at that time. Coordination was based on 4 major principles. The first one being single applicable legislation, whereby a national who moves to another European country cannot have more than one applicable legislation. This means that the national has an obligation to be subject to an applicable national legislation, and this person cannot pay social security contributions to more than one social security system. The second principle was equal treatment based on nationality. This principle established that a European Union national, and at present a national also from a third country, establishing himself or herself in that country, will enjoy the same rights of the nationals of the host country. Third pillar, aggregation of periods, which means that if in order to have access to social security benefits, you must prove evidence that you have been working for a number of years under some given circumstances and conditions, you can aggregate your periods of contributions in different countries in order to benefit from welfare benefits or social security benefits. For instance, you must have 312 working days in order to be able to enjoy an unemployment fund in Belgium, and if you have been working in Italy and Belgium, you can aggregate your contribution periods in order to apply for and benefit from an unemployment benefit. Fourth pillar, retention of rights acquired, which means that if you have acquired a right in a country, you can export that right to the host country where you are moving. So the portability or exportability of rights. Now, similarly, we could apply these rights to all atypical workers who are subject to employment contracts that are non-standard contracts. National social security systems and the EU coordination system were established at a time when employment was standard, which means one employer and a fixed term employment contract and a stable family context. New forms of employment have emerged, meanwhile, which are not covered by our national social security and social protection systems, nor by the European coordination systems. Therefore, we have a variety of national welfare systems creating new forms of protection which are also often atypical. So having to choose between harmonization and coordination, coordination was preferred, but the lack of harmonization had as a consequence that coordination has become challenging as well. They, in the field of atypical contracts and non-traditional families, the consequences are quite visible. At present, the situation is a dog biting its tail because atypical workers or precarious workers have a lower and precarious income when they work. They have weaker social protection or no social protection when they are unemployed, and they lose these rights when they move to another country. We've identified 5 types of hindrances to the free movement of atypical workers. I will list them shortly without going into the details. Number 1, lack of insurance coverage in employment contracts. Secondly, employment contracts that do not entitle workers to aggregate periods even when insurance contributions have been paid. Third, unemployment benefits that cannot be exported when you migrate. Fourth hindrance, the lack of minimum insurance requirements, which are unachievable for a larger and larger group of workers who are atypical workers. And fifth, the calculation methods for benefits, which become unbearable and impossible for, or non-viable for, workers who are not part of a standard framework. The main conclusion is that we need to take legal action. Litigation, and I am a sociologist, not a jurist, is the best way at present to have collective legislation progress, starting from individual cases. Individual cases enable plaintiffs to go to court before the European Court of Justice. It is mainly the ECJ rulings that have allowed rights of social protection to advance. Let me now make a comparison with rainbow families. Even in case of recognition of same-sex partnerships in Europe, as you can see, the scenario is extremely varied. It is, of course, very difficult to coordinate systems of countries that do not recognize the systems existing in other countries. For instance, in Belgium, same-sex adoption is recognized. Homosexual partnerships are recognized. Of course, when countries have such different systems, being able to coordinate such different systems is very difficult. As regards rainbow families, I have investigated the judgments of the European Court of Human Rights. And I have noticed that here too, the main way to go is litigation. Here you have a same-sex couple in a stable partnership, asking the Austrian authorities for permission to marry. This request was refused, so they went to the European Court of Justice. European Court of Justice gave a negative response because the convention does not compel state governments to allow for same-sex partnerships or marriages. Here you have a man who complained that the decision dismissing his request for authorization to adopt a child was arbitrary interference linked to his sexual orientation. Here too, the European Court of Justice rejected the application of the claimant, considering that the main point of interest was, of course, the protection of the child. In France, another case was a female applicant who thought and alleged that she had been discriminated against because of her sexual orientation and was refused the authorization to adopt a child. In this case, the European Court of Justice gave a favorable response to this claimant, saying that, by contrast, her homosexuality had been the main determinant in choosing to go for adoption. Here, you have a person who asked that the medical insurance be also extended to cover his partner, and the European Court of Justice refused this permission, saying that the Spanish government should protect families founded on the traditional marriage bond. Here, the request was not was for survivors' pension, whereas the case of the medical expense insurance concerned Austria. And in this case, the European Court of Justice maintained that there had been discrimination, but this discrimination was in respect to 2007, because afterwards Spain, Austria had amended its legal system. So I do not agree with our representative from the Ministry of Foreign Affairs, who said that the best strategy is small steps, one small step at a time. Of course, small steps are not bad, but history taught us that whenever a social break occurs, a change results. Of course, small steps create the conditions for change to occur. However, in my opinion, a turning point, a breakthrough is what we need, and legal action is the best breakthrough, especially when having to coordinate different social protection systems. Thank you for your attention.